All right. I'm going to kick it off. So today we're going to talk about joint assets, the good, the bad, the evil. And I'm going to share with you a story of joint assets. In fact, it was the file that got me into estates when I was in practice in my first year or so. A woman came in to see me, and she told me that her husband had just died, her estranged husband. So they had separated, and she handed me his will, which left everything to his sister. And she said, "Well, this isn't fair." So turns out this was the story, that they had separated, they had gone to family court, and there was an order for spousal support. It was a really nominal number. For some reason, I think it was like $100 a month or something like that. But it so enraged the husband that he had to pay her anything. Well, first of all, he went and changed his will, and he left everything to his sister. Didn't want anything to go to his kids. And then he wrote a note saying, "Haha, you guys get nothing. I've left it all to my sister." And he committed suicide. And that was his suicide note. And she said, "Is this fair?" And I said, "Well, there's good news. Um, and the good news is you inherit everything." And she said, "Really?" And I said, "Yeah." She said, "Well, what about the house?" I said, "Well, that was held jointly. And as soon as he died, you inherited 100%. And that was really the biggest asset. He had two other assets, life insurance and RSPs. He never changed the beneficiary on any of those either. And in fact, the spouse, my client, inherited everything, because although he had done a valid will, it didn't affect assets that passed outside the will. And the biggest of which was a joint asset. And the other side tried to argue that there had been a change in the ownership, et cetera. But in the end, she inherited everything. And it shows you the dangers, the evil, in a sense, of joint ownership when that's not your intention. So, and that was the case that was so cool to me, that this happened, that I literally, that's what got me into estates. So kind of an interesting case. So that brings us to sort of the first, the overview of joint assets, and then we'll get into some specific issues. But so John and Sue own something jointly. Joint ownership is obviously crucial. The ownership, the type of ownership, is crucial. So if John passes away, Sue is the 100% owner of that property. If, on the other hand, the property is owned by John and Sue, but not as joint tenants, as tenants in common, then what happens, of course, when John passes away is that Sue keeps her 50%, but John's 50% goes under his will. So a huge dramatic difference, just not by the different names on title, but just by those words that follow title as joint tenants. So true joint ownership it's a question of ownership. And this is why I try to constantly remind my clients that I really need to know who owns things, because right away they will tell you things are joint. Things are, "Oh, I own this jointly, I own that jointly." What they often mean is that they own it with someone else, that it's co-ownership. But as we know, joint ownership and co-ownership are two different things. The key element to joint ownership is this right of survivorship. The fact that when one dies, the deceased's joint owner's rights are extinguished. There's no transfer. There's no conveyance of an interest. It's simply that the owner's right, the deceased owner's right, is extinguished. They fall off title, and that occurs immediately. And the key element for our clients is that that means two things. One, that neither of you can give away your interest in that home in your will. That's the first thing. And the second thing is that the survivor is going to inherit that property, or receive that that interest with no strings. Absolutely. So as I say, there's always these only two options. One is is an absolute gift. There are no strings attached, and the survivor can do whatever he or she wants with it. That's exactly what happens when a joint tenant dies. A's name is deleted from title. B is the absolute owner. So what are the benefits and the problems, the good and the bad about joint ownership? And I'm sure you've been through this with the client, but I tried to break it down into the benefits and the problems. You'll notice I only came up with 4 benefits. I'm sure there are other more subtle ones. But the first benefit is that it's simple, right? It's just ownership. There's no will necessary. It's a mini will, in essence. That ownership, those words, as joint tenants, really create a simple will for that one asset, or a mini will for that asset. So it's immediately effective on death. You don't have to take any steps. Just like that woman, my client, who was sitting in my office, literally, she took no steps to inherit anything. She just, at the instant of death, boom, she automatically inherited everything. The big one that we think about is probate tax avoidance. That's certainly what drives so many of our clients to do things, to own things jointly, is this idea that probate tax is avoided with a true joint tenancy. So, and we'll get into that in a second, but true joint tenancy is going to avoid probate tax because that asset, at the instant of death, automatically the deceased's owner, rights are extinguished. Nothing passes through the estate. It's all automatic by operation of law. The other interesting fact, and this has come up a number of times in my practice, is it creditor proof? So, A and B own this property jointly. A has some creditors. A dies. Now A's creditors go after B and say, well, look, we want part of that. He owned that home jointly. The rights of that creditor are extinguished as against that property. They can't enforce it against that property because it's not part of the estate. Unless they register a writ, they get judgment and they register a writ of execution on that property before death. There's basically the survivor gets that property. Now, they could go after other property, but creditors can't go after that property. That is not, now when I say that, I'm talking about unsecured creditors, not a mortgagee whose interests are registered on title, but other creditors, for example. And the case that stands for that proposition is from the early 30s, Power and Grace, and there have been other cases that follow that about what creditors can do. So that's another benefit, for example. Now we get to the problems, and clients understand the benefits because often they've been advised by their financial advisor or someone else, or read it in the paper. Oh, you got to own everything jointly, and so they start running around putting things into joint ownership. Here are some issues that the problems with joint ownership. So the first thing is that if you transfer, let's take an investment property. Okay, that would be taxable. It's not a principal residence. I take my 50% and I take my 100% and I add a joint tenant on. So now CRA deems that I have disposed of 50% of my interest in that property by adding another joint tenant, and that could trigger tax immediately on that event. Income tax is not avoided on death by joint tenancy. Right. So this is another misconception that, if I own a joint, then I don't pay tax. No, you are deemed to dispose of 50% of your interest on death. Now, if it's a principal residence, there's no tax. If it goes to a spouse, there's no tax. But if I own something, an investment property, jointly with some third party, when I die, there's going to be a deemed disposition of 50%. On my death. So income tax is not avoided. Big issue for planning is when clients decide, I'm going to make one asset joint with one kid and one asset joint with another kid, and then I'm going to give the residue to a third kid. The income tax that's triggered on death, even by the right of survivorship, is going to be borne by the residue unless there's some sort of other mechanism in the will. And so Similar to making a beneficiary designation of an RSP to one kid and the residue to someone else, you're going to have the burden of the income tax on that, on the residuary beneficiaries who aren't getting that asset because it's passed by right of survivorship to someone else. For homes, you often hear people put their kids on homes as a joint tenant because they want to save the probate tax. Well, the problem is, without some documentation, they might actually end up losing, let's say they add one kid on there, 50% of the principal residence exemption because the kid is not living in that home. And CRA is going to designate or deem that to be 50% owned by the parent, for example, and 50% by the child. And so you've lost principal residence exemption. And people do this all the time for probate tax reasons, and then trigger all kinds of bad other issues. Big one, lifetime control. You add a person on as a joint tenant, you no longer have complete control of that asset. You have to, if you wanted to sell that home, for example, or mortgage it, you would need their consent. So that's a big issue for a lot of clients. Then you get into, what about the creditors and family law issues relating to the joint tenant that you put on property? To a creditor, that's going to look like it's an asset of for example, the son is on as a joint tenant. The son's creditors look on title, his name's on title, they slap a writ of execution on title. And now all of a sudden mom's home is subject to his creditors. Family law issues are similarly troublesome. Then there's the whole, I was just thinking this morning, what makes our job so hard? What makes our job so hard? It's that there are alternatives to wills. If everything simply went through the estate, if there were no trusts and no joint ownership and no beneficiary designations and no, none of those things, life would be so much easier. We could actually control everything through one document, but we don't. Joint ownership, as I said, is like a mini will. And that means that's going to go in one direction and your estate is going to go in a different direction. And it may create all kinds of unintended benefits because it's not necessarily thought of or conceived of when planning the will. And the last issue that we're going to talk about a little bit later is arguments over whether this joint owner is truly intended to receive the full benefit of that asset when the first joint tenant dies. Because we have this argument that really it's held, it was done for some other reason. It wasn't a true gift. It wasn't a true joint tenancy with a right of survivorship of both legal and beneficial ownership. And we'll get into that in a moment. So how do we change joint ownership? Because it's not unusual for us to be meeting, let's say in a blended family situation, and the clients say, oh yeah, we want everything. I want my assets to go to my kids. And, and you say, okay, great. Give me a list of your assets. And they list the home, et cetera. And they say, okay, it's joint ownership, or you do a title search, which would be recommended. And sure enough, it is joint ownership. And you say, well, you can't do that. You can't give that half of the home to your kids in your will. It's going to go to your spouse automatically with no strings. So the first thing is you have to change ownership. You have to change title. You can't do it in some other way, really. Although you could do a domestic contract, but you can't change it by will alone. You have to change title. And so you could do it that way, or you could sever the joint tenancy. So you could do that in three ways, really. So you can either agree with the spouse that we're going to change ownership to 50-50 or whatever. So that's one option. For real estate, there are a few other options. One for real estate is the spouse could say, without telling anyone, including getting the consent of their spouse, even if it's a matrimonial home, they can just register a deed that says, from A is the spouse, from A to A. A transfer to herself, from herself, is enough to sever the joint tenancy. You don't need the consent of the spouse, even if it's a matrimonial home, nor do you even have to tell the spouse. You can do that. And the case that says that you don't need consent is a case called Horn Horn and Evans from the Court of Appeal. So that's one option. That's an option you can, you see often in a separation. So if there are any family law lawyers out there, for sure, that's something that you will have come across, where one spouse wants to sever the joint tenancy so that if they die first, their spouse is not going to inherit. And you can do that. You can sever by agreement. Both people agree, we're going to sever, we're going to hold it, rather than we're going to hold it as tenants and joint tenants, we're going to hold it as tenants in common. But then there's this one, and this is the third one: severance by a mutual course of conduct. So this mutual course of conduct really is something outside of a joint agreement, where both parties are treating it as if they own 50%, not as joint tenants. Joint tenants is 100% ownership, undivided, versus 50-50 as tenants in common. And you see this for family law lawyers. You see this often where, for example, there's a matrimonial dispute. They own the property as joint tenants. Spouse A writes to spouse B's lawyer. The lawyers write to each other. One says, I'll buy you out of your 50%, or let's value it, et cetera. And the other writes back and says, no, I'll buy you out. At that point, what the case law suggests is those negotiations, those statements in writing, are enough to sever the joint tenancy, even though there's been no agreement. They haven't agreed one's going to buy the other out, but both of them are treating it as if they only own 50%. And that is the essence of this severance by mutual course of conduct. So even without prejudice letters, even instructions that a client gives to their own lawyer could be seen as a course of conduct. If the other joint tenant is doing the same, then that's a mutual course of conduct that could be used to sever the joint tenancy. And so before you get into any discussions as family law lawyers with your clients about the matrimonial home, I think it's important that you indicate that even discussions about it, and certainly writing to the other side, could end up severing the joint tenancy. And you can bet that if this other spouse dies first, your client is going to say, I never wanted to sever the joint tenancy, and look to you to say, well, why didn't you tell me this would have severed the joint tenancy? Of course I knew he was going to die before me, because they always know that. So that's something to be kept in mind for any family law lawyers. Simultaneous deaths of joint tenants. So if people die at exactly the same time, joint tenants, what happens is, by law, it's deemed to be a tenancy in common. Each owning 50%. So I just wanted to raise that. And then I just want to spend the last 10 minutes talking about presumption of resulting trust at PCOR, and a bit about how to deal with that in your planning side. So the well-known Supreme Court of Canada case, PCOR estate, dealt with the issue of legal ownership versus beneficial ownership. So legal ownership is what's on title. Title says two or more people own it as joint tenants. That is legal title. And there's a right of survivorship of legal title. That is, one of those names is going to get deleted from title when one dies. For married spouses, under the Family Law Act, if two spouses own something as joint tenants, there is a presumption that they own it truly, both beneficial and legal, as joint tenants, subject to proof to the contrary. Okay. We have a different issue for other people. The idea of beneficial ownership is, who is the real owner? Who is the real owner? Forget who's on title. Who is the real owner? And the questions really come down to this. Is the other person, if one person put all the money in and then put another person on title, the question becomes, did they put the other person on title for convenience, to allow them to manage the asset during lifetime, to have access quickly after death, or to reduce probate tax? If that is the reason that they did it, and in fact, the person who put all the money in, let's say the parent, really, that was their asset all along. It always is their asset. They intend to deal with it by their estate plan, but they've just put their kid on for convenience or quick access or probate tax reduction, then the court is going to say, well, the beneficial owner is really the parent alone, not both joint tenants. And there is a presumption of that case where it's an adult child being put on title as a joint tenant with a parent. And in that case, the court, the law, the court if asked, but the law presumes that that child, when the parent dies, is holding it in trust for the estate of the parent. And therefore it's governed by the will of the parent because it's part of the estate in essence, even though legal title was transferred to the surviving to the child. So yes, there's no probate necessary to transfer ownership, but its value is still part of the estate. And therefore, you have to declare that value for probate purposes, okay? Unless, if you have one will, and that will governs all of your assets, then it governs the beneficial ownership in these kinds of assets that are held on resulting trust for the estate. That one will is going to have to govern it because it covers all your assets. So how can we have our cake and eat it too? And many people are very familiar with this. But you could say, well, I'm not going to have one will. I'm going to use my multiple wills because I don't need probate to get title into the name of the child, the other joint tenant. But I still want it to be dealt with in accordance with my will. So to do that, you need, I think, two things. One, you need a separate will for assets that are held on a resulting trust for the estate. Because if you have just one will and you need to probate it, you're going to have to include the value of those joint assets that are held on resulting trust. So secondary will is recommended in that situation. The other thing that's recommended is a trust agreement. So something that declares that all the joint tenants recognize that who the true beneficial owner is, and that they're on title only as a bare trustee, in essence, only on legal title, and not beneficial ownership. What does that do? Well, that solves all of the problem. Well, that may alleviate many of the problems that we list here. For one thing, if there's no change in beneficial ownership, then there's no trigger of tax when you make the joint ownership. Now there'd be tax when the person dies of 100%, but there's no tax triggered immediately. So income tax is not avoided. That doesn't help us. The income tax burden is still on the residue, but nobody's getting that property. So there's not a problem there, a disconnect there. CRA generally takes the position that if you're putting somebody on who without beneficial ownership, so just a bare trustee onto title for principal residence purposes, they're not going to affect the principal residence exemption. The lifetime control, that trust agreement would say that the bare trustee, the child, for example, must do anything directed by the parent. They have to, if the parent wants to sell, then the other joint tenant, the child, has to go along with it. Now, there can always be a fight, but that's what the trust agreement could say. Furthermore, the trust agreement would hopefully protect it from the child's creditors and family law issues because they wouldn't be the beneficial owner. They will have declared that it was simply a bare trustee and they don't have any property interest in that asset. And it also alleviates the last concern, which is arguments over true intention. But of course, this is only if the parent, for example, doesn't want that child to inherit that asset with no strings outside the estate and separate from the residue. Because if they want to do that, then you don't want to do any of this. You want it to be a true gift of joint ownership. So that's what I had to say about joint ownership and what a problem it is for us. Usually the simplest issues and the simplest techniques can cause the biggest problems. And joint ownership in the wrong circumstances is not just bad, but it could create some evil as well. So let's open up the floor to any questions. about joint ownership. And while we're doing that, I'm just going to demonstrate something. So, so estate planner, if I click on the auto assign joint assets, it's automatically going to put any asset that is owned by more than one person in, or jointly into estate. And the good thing about it is that it also warns you about the fact that there's income tax here. There are on joint assets. It reminds me about documenting true intention for that, because it recognizes that we've got a kid, an adult kid, who's a beneficiary or a joint owner of property. And so it's saying you better document that. So those are some of the things that that estate can do. And this automatic sort of joint ownership, auto assign stuff is very helpful for speeding up the process. It also, by the way, shows the impact of joint assets. Here we've saved some probate tax just by having joint assets. So let's get to some questions. Same resulting trust presumption with other third parties too. Good question. So law presumes bargains, not gifts. So when there is transfer of property into names of other people who didn't pay for it, generally the law is like suspicious of that and says, well, why did this person make a gift? In fact, we're going to presume that there's that really it's not a true gift. It's a presumption of resulting trust. And so you do get that situation, resulting trust presumption, even with third parties. The big change in PCOR was that that it changed what was a presumption of advancement for children to a presumption of resulting trust. So my general concept is that wherever you see assets being gifted or transferred to a third party, that you've got to be ready to deal with a presumption that it was held on resulting trust and not a true gift. Next question. If adult child owns joint tenant with parent, do you need a declaration to rebut the presumption of parent being beneficial owners? Well, I think it's always a good idea whenever a person puts a child on title to have them do a declaration. Why? Yes, there's this presumption, but it's only a presumption. So what happens often is the kid puts, the parent puts the kid on title, and by the time the parent dies, the kid believes, for whatever reason, and maybe it's true, that it was intended to be a true gift. And then you get into, yes, there's a presumption it's resulting trust, but maybe there's other evidence that it was really intended as a true gift of beneficial ownership as well. And so for sure, documenting those intentions are very important, regardless of which way you're going, whether it is intended as a true gift, certainly under those circumstances, but also if it's if it's intended to be a resulting trust. So the question was, can a second will be used for a specific real estate to avoid probate? Well, I mean, assuming that that asset can be transferred without probate, then you could put it in the secondary will. So for example, if it was registry system real estate or land titles qualified, first conversion, sure, you could put that, or held on a resulting trust, sure, you could put that in the secondary will. So we finished with a minute to spare. I wanted to, first of all, wish everybody happy holidays and a happy new year, and looking forward to 2021 and hoping that that's a better year for society and for all of us. We won't be having another a webinar until the new year, but we really appreciate your interest and participation. And take care, enjoy the holidays if you get a chance to, and we'll see you in 2021. In the meantime, I'm going to just stay on and answer a few more questions if anybody has them, and I'll do that. So so question about principal residence exemption, the child's principal residence exemption. It doesn't. You can own multiple properties. You can only have one principal residence that and be exempted from capital gains. So as long as they have a principal residence that they own and that they're using as a principal residence and fulfills all the other obligations, and shouldn't really impact that. So I hope that helps.